I'm not following the agreement that you all have reached on this motion to revoke.
I'm just asking for a chance to get treatment and not go to prison. I do have a 4-year-old son that I'm fighting for.
The state of Texas is willing to give her an opportunity, so I'm re-urging the court to give her that opportunity. She's not asking for you to release her. She's asking you to send her to.
Right, why is the only tangent thing that I see from you is that you're picking up a new charge? Grant the motion to revoke.
American Justice Files.
All right, court is calling 2024 CR 007949, State versus Roxanne Hutchinson. Can I have parties announce?
I can gallery to see it. The defense.
And are you Roxanne Hutchinson?
Yes, ma'am.
All right, did you review the motion to revoke community supervision and state's motion to supplement pending motion to revoke with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Roxanne Hutchinson who's placed on community supervision in 2024 CR 007949 for the offense of unlawfully carrying a weapon with a felony conviction for 7 years on November 7th, 2024? Is that you?
Yes, ma'am.
All right, state.
Yes, are proceeding with violation of condition number 1 on or about the 19th day of February 2025 in Bexar County, Texas. The defendant, Roxanne Hutchison, committed the offense of theft in violation of condition number 1.
How do you plead to that? True or not true?
True. The state will waive and abandon the remaining violations, Your Honor.
Any objections?
No objections, Your Honor.
All right. Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, grant the motion, and sentence you up to 10 years in the prison?
Yes, ma'am.
And up to a $2,000 fine. Did you understand?
Yes, ma'am.
Knowing that, do you still wish to proceed with your violation of condition number 1 in your plea of true?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor, and it would involve the following case, which there's plea paperwork before the court for the same defendant.
Yes.
The state probation and the lead defense's recommendation is to continue probationer on this probation in cause number 2024 CR 007949, but to amend conditions to now include state ISF, cognitive track, followed by ISP. And probation did make a note upon disposition of pending cases, the plea paperwork on cause number, well, I see at 2025 AL 002862, there is a cause number I don't see right now, but those conditions would also reflect and run concurrent with this cause number.
All right. What has she done on probation?
Judge, the only thing that Ms. Hutchison has done on probation has been to provide her DNA sample as required.
She was recording. Sorry.
She was reporting. She reported last May 7th of 2025.
She had been reporting previous to that as well.
Right. I'm saying her last reporting is on that day.
All right. So here's my question. Has she done her parenting classes? All right.
Judge,
Did she obtain employment?
Judge, if I may inform the court, she was doing the parenting classes through CPS. Mm-hmm. She has a CPS plan because she's trying to get her child back through CPS. So she's doing the CPS classes through CPS. She has a CPS plan. So she's going through CPS. So she has a CPS plan. So she's doing her parenting classes through CPS.
All right, so how long has the CPS case been open? Was it open before this case?
Yes, ma'am.
So I don't understand why the court has received the new number one. She knows she has a CPS case, but she's picking up a new charge and she's not following through with the conditions of the court. I don't understand why I should follow the agreement to continue her.
Judge, I think she wants to
All right.
address the board.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Roxanne Hutchinson.
All right, why is the only tangent thing that I see from you is that you're picking up a new charge?
Hey, I know it doesn't reflect in the probation report or whatever, but since then I've kicked heroin. I've been sober for 9 months. I do admit that the issue wasn't me just getting sober. I got sober, but I was still doing the same things that an addict does. I was hanging around the same people. I didn't change my surroundings or my friends. So I continued to do the same things. I'm just asking for a chance to get treatment and not go to prison. I do have a 4-year-old son that I'm fighting for.
All right, so here's the thing. I don't understand why people don't think of their children before they pick up new offenses. I'm not following the agreement that you all have reached on this motion to revoke. I'm going to grant the motion revoke. Does anybody want to speak to time? She's looking at a maximum of 10 years. All right, yes.
Judge, I'm going to re-urge the court to consider following the recommendation from probation and what the state originally wanted. Ms. Hutchinson is before the court. She verbalized that she needs help. She's asking the court for help. It's not often that a defendant is before the court and they are asking the court for some help. She is asking for help also with CPS so that she can get help from CPS. It's well known that addicts relapse. That's not uncommon. And that's what happened with her. And because that happened, she picked up other offenses. The state of Texas is willing to give her an opportunity. So I'm re-urging the court to give her that opportunity. She's not asking for you to release her. She's asking you to send her to inpatient treatment so that she can get some help. That's what she's asking. And so I'm re-urging the court to consider that.
All right. The court, as previously stated, is finding violation condition number 1 true, and the court is going to grant the motion to revoke. Does anyone wish to speak to time?
I believe that we will be going open on that. The state understands defendant is facing up to 10 on this MTR. The other case that will be before the court shortly had thoughts. Basically, the state is thinking, we pled true to number 1, you're facing 5 or facing 10, state would ask for around 5, Your Honor.
All right.
Judge, we're asking the court to sentence Ms. Hutchinson to 2 years in TDC.
All right. This is what the court is going to do. The court will sentence you to 4 years in the prison. The court will request the therapeutic community. The court will give you a credit for any time served. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it?
Yes, please.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. Because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do y'all want to reconsider the plea bargain agreement with the theft case?
Yes.
Are there applications in this case?
No, Your Honor.
Did you understand you're charged with theft of property less than $2,500 with 2 or more previous convictions as state jail felony?
Yes, ma'am.
Just one moment. Are you all waiving?
No, Your Honor, we are proceeding with the repeater to make this a 3rd-degree punishment range.
All right, thank you.
Yes, Judge.
If you all could write the repeater on here, please. All right, do you understand if the state approves of the repeater enhancement paragraph, then this will be a third-degree felony. The range of punishment will be anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, ma'am.
According to the plea, the state is proceeding on count 1. And is she going to agree that she's been previously convicted for purposes of enhancement?
Once we get to the stipulations,
Y'all would check the box. You further agree that you've been previously convicted of 1 or more felonies for purposes of enhancement. Your punishment is to be assessed at 4 years in the prison. This will run concurrent with 2024 CR 007949. They were taking consideration 2025 CR 007240, 2025 PF 26020. There's to be restitution of $60 to the Bexar County Crime Lab and 2025 PF 26020. There's to be no contact with the complaining witness. Did you understand that to be your new plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
yes, it is, Judge.
Then she is charged. How do you plead? Guilty, not guilty, or no contest?
No contest.
And I'm sorry, to the enhancement, how do you plead? True or not true?
True.
All right, after reviewing State's Exhibits 1 and attachments, the court will find that there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
And I'm sorry, and also the court will find the enhancement true based upon your plea of true and based upon State's Exhibits 1 and attachments. Anything you wish to say on behalf of your client?
Judge, we're asking the court to follow the recommendation of the ADA and run it concurrent with the motion to revoke.
All right, the court will sentence you to 4 years in the prison, give you credit for any time served. This is to run concurrently with 2024 CR 007949. State will take in consideration 2025 CR 007240, restitution to Bexar County Lab. All right.
In this case, Roxanne Hutchinson was already on probation for unlawfully carrying a weapon as a felon when she violated the terms by committing a new offense, specifically theft, while still under supervision. Even though she admitted the violation and explained that she had been struggling with addiction but was now sober for several months, the judge focused on the pattern of behavior, especially the fact that she picked up a new charge despite having an open CPS case and a young child she was trying to regain custody of. Her defense and the prosecution both requested leniency, suggesting treatment and continued probation rather than prison, emphasizing that relapse is common and she was asking for help. However, the judge rejected that recommendation, stating that repeated noncompliance and new criminal conduct outweighed those considerations, and decided to revoke her probation. She was then sentenced to 4 years in prison, with a recommendation for participation in a therapeutic treatment program while incarcerated. In a related theft case, due to her prior convictions, the charge was enhanced to a third-degree felony, and she accepted a plea deal for the same 4-year sentence to run concurrently. The court made it clear that while treatment might still be available in prison, her continued violations and failure to fully comply with probation conditions ultimately led to incarceration rather than another chance in the community.